uphold and defend the Constitution, and he's calling me and my industry, which provides the law enforcement and the military their firearms.
Roughly 40 million firearms with stabilizing braces in circulation to obtain a special registration.
From engaging in defense from imminent harm.
Large capacity magazines increase
in this issue. But here's the facts. Due to ATF's unilateral and unconstitutional action, okay?
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
In effect, banning, or at a minimum, severely restricting.
Joe Biden stood on the debate stage with all the other Democratic candidates and said, the firearm industry is the enemy.
In most public places, even with the concealed carry permit, is now in effect, even as the case makes its way through the courts.
ATF appeals and legal battles. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, or ATF, has taken 5 pistol brace cases to the Fifth Circuit Court of Appeals. This has made the legal fight over the ATF's rules on these arm accessories even more heated. There are 2 important cases, Monk v. Garland and BR v. Garland, which were very important in getting the ATF's arm brace rule overturned. The Firearms Policy Coalition, FPC, started the Monk case, which has been very important in getting good results against the ATF's arm brace rule. On the other hand, the BR case, which led to a national ban on the ATF's rule, was a big win for people who support the Second Amendment. The ATF's choice to appeal these cases shows that they're trying to find help and maybe even undo past mistakes. Many groups, such as the FPC, Gun Owners of America, GOA, and the Second Amendment Foundation, SAF, are constantly challenging laws about pistol braces, so the legal situation is always changing. As a result of these appeals and later court decisions, the rules for pistol braces will change, and so will the larger debate in the U.S. about arm rights and restrictions. As the legal fights go on, the complex issues of interpreting the Constitution, making administrative rules, and Second Amendment law will be at the heart of settling these cases. As an example of the larger fight about arm rights and laws, the Monk v. Garland case is a major legal battle. When the Biden administration tried to control pistol braces, groups that support arm rights, like the FPC, fought back hard. For people who like arms, pistol braces have become popular accessories that make using pistols more stable and easy to use. The National Firearms Act, NFA, changed the definition of these weapons to short-barreled rifles. This was a big change in policy, and law-abiding arm owners were worried about how it might affect them. The Fifth Circuit's decision to back the challenge and the following enforcement order showed that the court agreed with the plaintiffs' legal arguments. The district court granted the injunction because it knew that the plaintiffs would suffer irreparable harm or difficulty without temporary relief. Even though this enforcement order gives everyone a break, it also sets the stage for a longer legal fight. Now that the case has gone to trial, the larger arguments for and against the challenge will be carefully looked at. The court cases about pistol braces and the scope of Second Amendment rights will have a big effect on how things are regulated in the U.S. The Firearms Policy Coalition, FPC, filed a case against the Department of Justice's rule that treats pistol braces like short-barreled rifles, or SBR, which are strictly controlled by the NFA. This change in the classification of the rule was very dangerous for arm owners because it put them under a lot of restrictions and required thorough background checks. At first, the Federal District Court turned down FPC's request for a preliminary injunction. The court agreed with the ATF that the plaintiffs hadn't shown that the agency had gone beyond its legal power at that time. The Fifth Circuit Court of Appeals didn't agree with the district court's ruling, however, after an interlocutory appeal was made. The appeal court agreed that the ATF had gone beyond what it was allowed to do under the APA. As a result, the case was sent back to Judge O'Connor to be looked at again. Supreme Court's 5-4 emergency order. In the next case, BR v. Garland, Judge Kaczmarek issued a preliminary injunction and a nationwide injunction against the entire pistol brace rule. This protected not only the individual plaintiffs, but also FPC and its members, as well as Maxim Defense, a company that makes pistol braces, and their customers and families. The injunction's national reach makes it stronger, protecting many people from the ATF's overreach. The long court battle over pistol braces shows how important it is to fight government actions that violate basic rights. Both the Monk v. Garland decision and the BR v. Garland decision sends a strong message about how important it is to follow both administrative law and constitutional rights, especially when it comes to the Second Amendment. As these cases go forward, they could set a precedent and change the law about limitations on weapons and the power of government organizations. A 5-4 emergency order from the Supreme Court to stop the decision on short-barrel rifles and pistol braces has caused a lot of raw experts, scholars, and arm control supporters to give their thoughts. People who want tighter arm laws say that the emergency order shows that the Supreme Court needs to carefully think about the risks that come with people having unrestricted access to arms. Supporters of the Second Amendment see the emergency order as a key step towards protecting people's rights to keep and bear arms without needless government interference. Many experts stress how important it is to have a deep understanding of the law and constitutional issues at play when judging the emergency order's effects. A constitutional law expert, Professor John Doe, says the emergency order doesn't set a clear precedent. Instead, he says it shows that the Supreme Court understands how complicated the legal issues are that surround arm control.
Uphold and defend the Constitution, and he's calling me and my industry, which provides the law enforcement and the military their fire.
That is not a priority.
Okay, here's the problem we have. Here's the problem we have. Okay, you ran for Ohio Attorney General in 2018.
All the policies that he's laid out are demonstrating that he is doing everything that he will to destroy this industry.
And in those cases, firearms dealers on the southwest border are required to make a multiple sale report.
Not long ago, the Supreme Court ruled 5tighter arm laws say that short-barreled rifles pose special problems because they're hard to hide and could be used for illegal activities. They say that putting limits on these weapons is a sensible way to protect the public. The emergency order makes people wonder if the Supreme Court is really going to think about how easy it is for people to get certain kinds of arms. On the other hand, people who support the Second Amendment see the emergency order as a key way to protect people's right to keep and bear arms. Their argument is that rules that target certain arm parts, like short-barreled weapons, violate people's constitutional rights without a good reason. People who believe in a strict reading of the Second Amendment see this ruling as a win. They want to stress that everyone has the right to own arms for lawful reasons, including self-defense. This ruling has effects that go beyond the current case. It sets the stage for future court cases and changes the way people talk about arm control in general.
We crushed it, baby! We crushed it!
Roughly 40 million firearms with stabilizing braces in circulation to obtain a special registration.
And yet at Uvalde and in so many other school shootings, we were not willing to protect our children.
It's important that our Constitution does have a Second Amendment.
I think that all the amendments are important. It's very hard to start comparing.
From engaging in defense from imminent harm.
Large capacity magazines increase.
Legal experts and scholars are paying close attention to how this ruling might change how the Second Amendment is interpreted in the future. Some say that it shows how important it is to look at arm rights laws in a broad and complex way. The fact that the justices were split 5-4 shows that there is still a lot of disagreement in the law community about how to balance personal freedoms and public safety when it comes to arms. People who are against the emergency order are worried about how hard it might be to enforce the same arm laws across the whole country. Without clear rules, it might be hard for states to put in place effective arm control measures that work for their specific situations. This could cause a patchwork of rules that are very different from one state to the next. This would make it hard for police to do their jobs and make public safety measures less consistent. The main point of disagreement is still how the emergency order will affect public safety. Supporters of the Second Amendment stress how important it is to protect individual rights. Opponents, on the other hand, say that rules are needed to keep arms out of the wrong hands. No matter what the final ruling is, it has started new discussions about how to balance individual freedoms with the safety of everyone. In conclusion, the 5-4 vote to issue an emergency order blocking
Tell us that we can't have this brace.
Supreme Court's impact on arm laws. In the case of New York State Rifle and Pistol Association v. Bruin, the Supreme Court threw out the rules of law that lower courts had been using before the case. The court ruled that the current arm laws should be judged by how the country has controlled arms in the past. Though the Bruin theory was meant to make it easier to follow Second Amendment rules, it hasn't been able to get courts to make decisions that are consistent and well thought out. Since the Bruin decision, people who use the Second Amendment to fight arm laws have had a lot more success than they did before. There have been 21% more successful challenges to the Second Amendment than there were between 2008 and early 2016. This is a big increase from the 9% of successful challenges that were made between 2008 and 2016. There are, however, very different views among judges on whether or not different arm control laws are constitutional.
Striking a clause in the preamble is per se germane, neither adds nor subtracts, and police.
But now you secretly let out what the real purpose of it is. It's to claim that Democrats...
Bills for National Police Appreciation Week, we took up the actual bill.
And no one contends otherwise. But what are the limits? Wouldn't it be nice to hear?
It requires agencies to submit a rule to Congress before the rule can take effect. After submission of a rule by the agency,
some think it's legal to ban assault weapons, arms without serial numbers, high-capacity mags, ghost arms made by criminals, people who use drugs, people who own arms, people who've been convicted of non-violent felonies, and sensitive places like schools, summer camps, places of worship, and public transit stops for kids. Others think it's not. The Supreme Court can learn from the Rahimi case how to understand past policies and look at the present with a fresh eye. This case is about whether the Second Amendment is legal and how it helps people who have been abused at home. More than half of the killings of women in the United States are done by close partners, and more than half of those killings cause an arm injury. If the Supreme Court agrees with the lower court, the federal rules that were used to fight domestic crime will no longer be valid.
In effect, banning, or at a minimum, severely restricting
figures. And this is something that we should celebrate, that today's gun owner is looking a little bit less like me and more like the rest of America.
The limited exemptions are negligence, knowingly selling to somebody who's not allowed to have a firearm.
Weapons ban is constitutional. So we know dangerous and unusual weapons are outside the scope altogether.
I believe, to infringe upon good law-abiding Americans' rights, and you're going to turn them into criminals with this regulation, and you seem to have no remorse about it.
17 states and Arm Owners of America sued the ATF over a new rule about frames and barrels that aren't finished. The 8th Circuit Court of Appeals made a choice not long ago. It was asked for by the North Dakota District Court so that the ATF could not apply for it. After hearing what Bruin and other people had to say, District Court Judge Peter Welch ruled that this case didn't need an injunction. ATF's frames and receivers rule was temporarily blocked by the 8th Circuit. This has made people wonder what the Supreme Court will do next. When the Bruin decision came out a month before the final rule, it was only about concealed carry at first. After the preliminary injunction was denied, it was said that it wouldn't apply to this case. In the Federal Circuit Court, DOA took the case to a 3-judge panel from the 8th Circuit. The judges didn't look at the case's chances of success on its own grounds. As the next step in the 8th Circuit, DOA asked for a review by the whole panel after the decision. Right now, the 8th Circuit's top court doesn't want to deal with this issue. However, DOA can now ask the Supreme Court to look into it or make a new GARI.
The Supreme Court heard both sides of the argument for the Second Amendment Preservation Act. On one side,
predisposed to put criminals in jail, and finally, liberal district attorneys.
This case, because this law has posed substantial threats to public safety.
Simple. I will read, if I can find underneath all these amendments,
and their recent actions against firearms manufacturers, federal firearms licenses, or FFLs,
or policies as before us today to make it harder for law-abiding citizens to obtain firearms.
Year-old adults, guns that are in common use. It bans for everyone.
Legal analysis of AR-15 lower receivers. We're in Ohio in 2019, and the case is U.S. versus Rowland for those of you on your lawnmowers. Mr. Rowell was found to be in possession of 15 AR-15 lower receivers, which is basically a crime. He was charged with having an arm because he had those 15 lower receivers, but why that was a crime for him isn't really important because we're only interested in whether those low receivers themselves are an arm. The company that came up with it called it the 15th version of different prototypes and designs. It's basically a two-part system made up of an upper receiver and a lower receiver. Neither the upper nor the lower receiver can fire the arm on their own. The top receiver holds the bolt and makes it possible to insert the barrel. The lower receiver holds the hammer and the firing mechanism. An AR-15 lower receiver, which the ATF considers to be an arm, is essentially just a container that would hold the hammer and the firing mechanism in a fully assembled arm. Yes, it also holds the stock, the grip, and other accessories, but for legal purposes, the hammer and the firing mechanism are what makes it an arm. This is important because the Gun Control Act of 1968 defines an arm as we're mainly interested in options A and B, and especially B, which is the frame or receiver of any such weapon. This is because an AR-15 lower receiver by itself can't be easily converted. It will take a little more work. That's why we're mainly interested in this as the frame or receiver in this case, since receivers go to long arms and frames go to handguns.
In this issue, but here's the facts. Due to ATF's unilateral and unconstitutional action, okay?
And I was sharing with you my knowledge of a program in which ATF has defined this term.
Joe Biden stood on the debate stage with all the other Democratic candidates and said, the firearm industry is the enemy.
Weapons ban is constitutional. So we know dangerous and unusual weapons are outside the scope altogether.
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
The Bureau of Alcohol, Tobacco, Arms and Explosives, or ATF, made a regulation that fills in the blanks. It says that a frame or receiver is that part of an arm that provides housing for the hammer, bolt, or breech lock and firing mechanism. It's important to note how the commas work here. Hit it hard 2, the bolt or breech lock, and 3, the firing mechanism, which is usually threaded at its forward end to receive the barrel. You can find that information in the Federal Register at 27 Section 47811. Let's put this all together. Does an AR-15's lower receiver hold the hammer? Yes. Does it hold a bolt or breech lock? Yes. It's also not threaded at its forward position to accept the barrel, and it never has been. This is a big problem. Congress didn't give us a definition of a frame or a receiver, and the only one we have comes from the ATF. According to their definition, an AR-15 lower receiver isn't an arm because it's not a lawful receiver, which makes it an arm. But neither is the upper receiver by itself. So can we make the legal case that an AR-15 isn't legally an arm? At least not those parts. The upper or lower receiver aren't lawful.
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
We can expect in the future that more people will be carrying handguns.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
Because people buy hundreds of guns legally and then they sell them illegally.
About a new law that would bring big changes to the workplace, but there are also several new laws that will impact public safety.
Arms under legal scrutiny. Under this argument, if you put the whole thing together, there's an argument for the fact that we're checking the first one, that this is any weapon, including a starter arm, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. So when you put the entire arm together, it's a weapon that fires bullets. However, when you break it down, it doesn't nearly fit this definition, and that's the crux of the arguments presented in court. The defense filed a motion to dismiss, contending that these lower receivers, essentially chunks of metal, typically made of aluminum, though sometimes carbon fiber or other materials, do not qualify as receivers under the ATF's own definition. The government responded by asserting that this motion to dismiss should be disregarded, emphasizing that the ATF has consistently applied its regulations to bring AR-15 lower receivers within the Gun Control Act. In essence, the government argued, "Judge, you have to throw this out because we've always done it this way." However, the judge didn't find this argument compelling. He pointed out that there's no limitation period in this situation and wrote, "Misapplying the law for a long time provides no immunity from scrutiny."
This government can protect its own people except for 36 out of every 100,000 for murders.
Changed so significantly since 1791.
Yes, just a bit, right?
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's a time for a big change.
Still consistent with the Second Amendment, even on the Supreme Court's reading of what it includes.
The judge further noted that the Supreme Court has already provided an answer to this type of argument, stating, if a violation of a regulation, which is what we have here, subjects private parties to criminal or civil sanctions, they virtually all do, a regulation cannot be construed to mean what an agency intended but didn't adequately express. Moreover, the judge asserted that the government failed to demonstrate that either Chevron or the differences in interpretation call for a different outcome. In other words, simply relying on past practices and interpretations doesn't absolve the government from meeting the standards set by the law. This legal debate underscores the complexity and nuances involved in determining the classification of AR-15 lower receivers as arms under ATF regulations, making it a matter that demands careful consideration and adherence to legal standards.
The same level of attention and media, as well as law enforcement, is not dedicated when a young African American.
In June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
Most apparent here, a defense of the Second Amendment, which this most certainly is.
Navigating the legal landscape. Essentially, these arguments hinge on the principle of Chevron deference, advocating that administrative agencies should enforce and interpret their versions of government statutes and laws passed by Congress. However, the judge in this case contends that the demand for deference doesn't consider the directive that there's no good reason for a deference if there's no uncertainty. In simpler terms, the judge argues that Chevron's rules only apply when there's uncertainty or ambiguity in interpreting and applying a certain administrative rule. In this case, the judge asserts that there's no ambiguity because the rule is clear. An AR-15 so-called low receiver is not a receiver, and the upper receiver isn't either, permitting the agency, under the guise of interpreting regulations, to de facto create a new regulation is not permissible, according to the judge. The judge raises concerns about continuously interpreting and reinterpreting without changing the words, emphasizing the need to avoid overstepping the bounds set by the Administrative Procedures Act, APA, the Constitution, and other legal frameworks. The judge underscores the importance of agencies proposing new laws within the limits of legal procedures.
In most public places, even with the concealed carry permit, is now in effect, even as the case makes its way through the courts.
And I was sharing with you my knowledge of a program in which ATF has defined this term.
Analogous historical tradition of regulating weapons that would make an assault weapons ban.
Where they were labeling their weapons. Would there be a label on the wall for assault weapon?
However, he draws the line, asserting that continuous reinterpretation without changing the words raises significant issues. The judge points out that this issue isn't a recent discovery or invention of the court. He references a 1971 Internal Revenue Service memorandum, the precursor to the ATF at the time, acknowledging the challenges in defining the M16 receiver, highlighting the practical solution of considering the lower portion as the receiver. He also alludes to the ongoing legal proceedings related to the new frame receiver rule, addressing issues such as the split frame or receiver expanded interpretation. This may be connected to recent discussions, like the one in the Fifth Circuit, indicating a nuanced approach to striking down specific sections of the ATF rule. The judge acknowledges that the rule remains in effect, pending further legal considerations, emphasizing the role of the Supreme Court in upholding the rule temporarily. While the regulatory landscape remains complex, the judge suggests that the ATF over the years left a door open for deregulating AR-15s and other arms, which may lead to significant implications for gun control laws. And that's going to do it for this video, guys. See you next time, and bye for now.